We are ready to start. So, Rachel, you want to take over? She there? I think she's on mute.
Rachel, you're muted. Yeah.
Really, and my video's not on. Okay, I'm going to try and screen share again if I can. No. Trying to figure out.
Dr. Fulton will have to make you a presenter since he's the host now. So he can just click on your name, and I don't think I can do it anymore because here, make presenter.
There you go. Got it.
There.
I got it.
Now the presenter.
Try now.
Okay. There we go. Okay, guys. So what we're looking at adopting is a custom, single, comprehensive, non-discrimination, non-harassment, non-retaliation policy that will encompass what we previously had in our structure as multiple non-discrimination policies sort of spread out in different sections. It was spread out in Section A, Section J for students, Section G for employees, as well as in Section K. This is going to be a more usable, accessible policy. It was needed for a couple reasons. One, I have been wanting to restructure it because I think a single policy is better. I think it's easier for anyone to use, whether they're somebody who feels like they need to report prohibited conduct or whether they're an administrator trying to implement the investigation procedure. It was needed because we have new Title IX regs that were implemented by the Department of Education. And also, I can't think of a better time, given current events, to be carefully looking at our non-discrimination policy and making sure that it accurately reflects our commitment to have an educational and work environment that's free from discrimination, but also our commitment to addressing prohibited conduct and communicating to people what the steps are that we take when we receive a report or complaint of prohibited conduct. The policy has a couple different sections. The first one is our statement prohibiting discrimination and harassment and retaliation. This will be the basis for our non-discrimination notice that appears on our website, in our contracts, anywhere else that we put our non-discrimination statement. The next section bullets out all of the different federal and state laws that are applicable to K-12 public education and prohibit forms of discrimination, harassment, and retaliation. So those are all bulleted out along with a short summary of what those acts prohibit and sort of the protections that they guarantee. The next section is our statement that we are an equal opportunity employer. The next section includes definitions of what constitutes prohibited discrimination, harassment, and retaliation, along with specific examples of conduct that could constitute discrimination or harassment. We did just change, by Jessica's suggestion, which I think is really helpful, we added language that specifically identifies name-calling, insults about personal appearance or hair, and that's broad, so whether it be hairstyle or hair texture, includes those as potentially harassment that would be prohibited under this policy. And I think that those specific examples are helpful because as we're walking staff members and students through this policy, which will be included in our student and staff handbooks, we can go through those examples to make sure that everybody is on notice of conduct that's not acceptable. Specific definition of sexual harassment, and along with a statement that it can occur between persons of the same or opposite sex. And definitions for retaliation and what are protected activities that an individual cannot be retaliated against for engaging in. We have designated a new compliance coordinator. That position will be held by both Dr. John McKinney, our Director of Student and Family Services, and by me jointly. So we will work together and use our strengths and our different abilities to make sure that we are fulfilling all of these responsibilities. And at a high level, those responsibilities are making sure that we are familiar with all of those laws that were listed previously, that we have a policy that works, that we are training our staff, and that we are training our students on this policy. The next section sets forth the reporting responsibility for our staff members and makes clear that any staff member who becomes aware of prohibited conduct occurring in the educational environment or the work environment is responsible for reporting that conduct to the compliance office, to the compliance coordinator directly. And that's how we will train staff. It's not enough just to pass it along to your immediate supervisor. It needs to come to the compliance coordinator. And in our training, we will make very clear that that is me and or John, so that we make sure that the individuals who oversee this process are aware of it and that it's being investigated in accordance with this policy. The sort of inserted paragraphs or indented paragraphs under the reporting responsibility is a reminder that prohibited conduct could also be conduct that needs to be reported as a crime or as child abuse or neglect. And that is our first step, no matter what, is evaluating whether our mandatory reporting requirements are triggered and making those reports before we start to walk through this policy. The next section makes clear, or this sentence makes clear, that employees who fail to report could be subject to discipline. And then the next statement makes clear that all other individuals in our school and work environment, which includes our students, our parents, our community members, contractors, they need to report prohibited conduct as well. And then the next section is our grievance process. So this is how we address prohibited conduct that gets reported to us. It starts off with some definitions, including who might be a complainant, who might be someone who brings forward a complaint, how a formal complaint is filed, the definition of respondent, which is essentially a perpetrator, an alleged perpetrator of prohibited conduct. It gives the definition for supportive measures, and those are measures that we would put into place immediately after receiving a report. Those are non-disciplinary measures, and they can look like many different things, but basically the goal of an interim supportive measure is that, hey, we haven't determined whether a policy was violated or not, but we know we have somebody who's concerned that they were treated in violation of this policy, so what can we do to keep them feeling comfortable in their school environment or their work environment? Including a range. So this should be helpful to both administrators who are implementing the policy and the complainants to get ideas. It's not an exhaustive list, but it's ideas for what kind of supportive measures we can offer to both our students and to our employees. For all types of complaints, except for gender or sex-based complaints, we're just going to have an investigator who investigates. That's our procedure right now, and who determines if our policy has been violated. We have, based on job duties, we have identified different investigators. So if it's a student-on-student prohibited conduct, somebody at the building is going to be investigating that. If it's a student-on-staff situation, we're going to have a principal at a different building do the investigation. And the reason why I wanted to do that is because I think you could have a building principal who feels an obligation to protect their staff member, so they could have a conflict of interest and not be able to look at it in a non-biased way. We rarely see these. It's not often that you get a complaint from a staff member that a student has discriminated against them, but it could certainly happen. And then for any staff-on-staff complaints, that's going to be looked at by a human resources director or coordinator. For Title IX, the new regs mandate that the person who does the investigation is not the person who actually makes the decision. So we have to have a separate decision maker who will review the investigation work done by the investigator and then determine if our policy has been violated or not. So we've designated somebody to do that. Remedies are what is instituted if a violation of the policy is found to have occurred. So supportive measures happen all the time. Remedies are things that we do, that we put into place when we have a violation. And even if we're in a situation where we can't discipline conduct because maybe it happened off campus, didn't impact the school environment, there's still a lot of other remedies that we have. And, thanks to Dr. Bates, he's a lot of great ideas for things that we can do to try and help both educate people who maybe violated this policy, but also make sure that someone who is a victim is comfortable in the school or work environment. And then we do have an appeal process. And so if someone does not agree with the decision at the first level, they have an ability to appeal to the deputy superintendent or designee. And then the last section just kind of sets out an overview of our grievance process. It makes it clear that we're going to cooperate with law enforcement if they're doing an investigation, but sometimes we might have to march forward with our investigation the same time as the law enforcement investigation is going on. It makes clear that complainants can also file complaints with other outside agencies. We will still enforce our policy. We will still investigate. So they can do both. They always have the option of filing with an outside agency. And this is language that we didn't review in executive, but I thought was really helpful. So the new Title IX regs, one of the big underpinnings was that they felt like a lot of times there was no presumption of innocence for a respondent. And they make clear that you need to start with a presumption of innocence, just as you would in a criminal process. But the language that I included, which I hope is helpful to anyone who feels like they need to report conduct that violates Title IX or any other provision of our policy, is that, let's see, where did I put that? Investigations will begin with a presumption that the respondent didn't engage in any prohibited conduct, right? So presumption of innocence, but also that the complainant is credible. And I think that that's important. That is the presumption that we start off with. We're not going to make an assumption that the alleged perpetrator engaged in the conduct. We're not going to make any assumptions that what was being told to us is not true. We're going to start off with the basic assumption that you are credible and that you are coming forward with truthful information. And it's not until we tease out all the evidence that we would make any credibility determinations. This is also part of the new Title IX regs. You can't look at past sexual behavior of a complainant. Where that most likely is going to come into effect is where you have a student-on-student complaint and someone says, we had a consensual sexual relationship and we've had it for some time. And so the new Title IX regs say that you can't consider that. You can't consider past sexual behavior except in the limited circumstance where it's offered to prove consent or that someone other than the respondent committed the alleged misconduct. And again, it would be very atypical that we would be looking at that anyway in an investigation, but that puts the boundaries on it. This section, and again, this is required by the new Title IX regs, they say you need to make sure that you put everyone on notice of what possible consequences could be. So we've put a whole range of discipline in here, and just so that everyone knows, I did consult with Dick Kramer and make sure that these possible consequences align with our new discipline code that they've been working on. Again, this wouldn't foreclose, even if we impose discipline, this would not foreclose all the other great remedies we have, like educational endeavors and rehabilitation and all that sort of stuff. The decision to impose discipline would depend on the specific facts, would depend on whether the conduct also violated our discipline code. And then here's just kind of the step-by-steps. Again, our previous policy did not do a great job of I felt like of taking us through the timeline and first this happens, then this happens. And so I tried to make it very, very clear. First, step A is that we get notice of the complaint, we offer supportive measures. The next step is that we get the complainant to go ahead and fill out a complaint form. And if they won't, then the compliance coordinator can decide to go ahead and initiate an investigation anyway, depending on the circumstances. Then the investigator would kind of they would do interviews, they would look at any surveillance video, they would look at any other records, and then they put together a report. That's sort of the last step unless we have a Title IX complaint. And if we do, there's a couple more steps that the new Title IX regs lay out. And that's because the best summary I can provide of those Title IX regs is they turn it into more like a court or legal proceeding where the parties can have advocates, they can have attorneys representing them, they get an opportunity to sort of review some of the evidence from the investigator's investigation and respond to it. So when we have any complaint that implicates Title IX, we will go through these additional steps. And then there is an opportunity to appeal to the deputy superintendent if you disagree with the investigator's decision, or in the case of Title IX, with the decision maker's decision. This section makes clear that the investigation is confidential to the extent that we are permitted to keep it confidential by law, and that we are going to retain these records centrally. And just so everyone knows, the notice letters that go out, those will be in the investigation file, but also they'll go in individual student and employee files. And I think that's important because if we later have an allegation against the same individual, we would be able to go through, for example, their personnel file and see that notice letter. The next section affirms that we're going to do regular training on this policy and specialized training for the individuals who are designated to be the compliance coordinator, the investigator, the decision maker, or the appeal officer underneath this policy. And then the last section there affirms where we're going to give public notice of this policy, which is going to be everywhere. It's going to be all over the place. Here is the list of policies that we can delete out. Again, now we have a central unified policy. And so the language and the affirmations and all these other policies now live in our policy AC. So we're not deleting any of those commitments from those policies, but rather we're just moving them to policy AC. And then there's a couple policies that, because we're changing the structure of our non-discrimination policy, we needed to go through and revise just to make sure that they were accurate and they marry with our new structure. And so our policy about staff complaints, I made a couple minor updates, but just deleted out the last sentence that has to do with discrimination or harassment complaints. The new language in policy AC affirms that all of our board policies are going to be carried out in accordance with policy AC. So we don't need to specifically go through in individual policies and affirm that. They all will be carried out in accordance with policy AC. Our student transfer policy, our policy for in-district transfers, had a minor reference to the old structure, so that's deleted out there. Our same thing for our student complaint policy. It had a reference to complaints of discrimination and harassment, and so all that language now appears in policy AC, and so this policy will just be limited to other complaints, like complaints about school rules or procedures. And then finally, we used to have most of our investigative steps in policy KN. We're deleting all of those out, and policy KN will now just address public complaints. So complaints from parents or complaints from community members and how those should be addressed. And I think that's it. That's my speech.
So quickly, I just had a question on how many people were involved with this and how long have you been working on this?
I've been thinking about it. I think I've been thinking about it since my first day with the district, because I knew, based on working with school districts, that I didn't like the structure. I knew these Title IX regs were coming, and then I had an idea of what they were going to look like. And then once they were finalized, I think it's like 3 or 4 weeks ago now that they were finally finalized. I then had an idea of the new language that we needed in our complaint. This has been vetted extensively internally, because I think it's really important that we have buy-in, but also sometimes as the district's general counsel, I miss out on parts of basic school operations, if that makes sense, like how things actually happen in a school building. So this policy was run by the entire executive leadership team, who kindly listened to this entire spiel that I've just given you. So Dr. Bolton's now heard it like 5 times. It was then vetted with Dr. John McKinney and Dr. Bates. We, I think, talked for 3.5 hours. It was an awesome conversation. They were both really excited about it. And Dr. Bates gave me some really good, just some good insight about how we needed to rephrase a couple things. So I think it was a lot stronger after it went through him. And he was also able to illustrate for John and I, when we talked, how he fits into this policy, right? So where he could come into play, what he could offer if we had a violation or we had a victim who was really uncomfortable coming to school or work. So that was a really great conversation. And then ran it by Dick Kramer to think about it in light of our new discipline code and make sure that it married up with that as well. Then I think I ran it by ELT like a whole nother time. So it's been passed around. I think it's really strong now. Oh, and I've also ran it by some of my school law colleagues, just to try and get their idea on this structure and what we do with the new Title IX regs and how we have a single investigation process. I think some of them are going to steal my work, frankly, but that's okay. So lots of conversations to make sure that this is going to work for us and it's going to do what we want it to do. So,
Jessica, any questions?
I have a few just kind of clarifying and confirmatory questions. One, to confirm the reason why we feel comfortable taking out so many of these other references that are kind of embedded, like, for example, within the transfer policy, is that as you have drafted policy AC, it kind of includes a blanket statement that just says, like, OPS, this applies to every single policy we have in the district, and we don't have to continuously refer back to saying that, like, transfers will be in accordance with this policy. We don't have to do that over and over again because it's there we go. That's the piece.
And I also think it's a little weird to pick out some policies where you highlight that, because the implication there is only these policies, right? And that's not the case. All policies should be implemented with this in mind. So I think that's a better way to do it, is right at the outset. All of our policies, all our procedures, all the steps that we take will be implemented in accordance with this policy, which prohibits all forms of discrimination and harassment.
Another couple questions I had. So in terms of who's the assigned investigator, or there's like, it's spelled out who will be the assigned investigator for student-on-student harassment complaints, and student on staff and staff on staff, but what about staff on student investigators?
Oh, good question. Thank you. Okay, so this is what I did with that, because not only could we have that, we could also have, for example, a volunteer within our school community potentially violate this policy, or community member, a visitor, whatever. There could be other perpetrators. So what I did here is all other formal complaints. And so if we have, and maybe actually, since you've raised that, I'm wondering if it would be helpful to specifically put that in here, is to say, just to make it clear, because if you had that question, Jessica, I think other people will. But if it involves a staff member, someone in human resources would investigate. The staff member is the perpetrator. Someone in human resources would investigate. The reason why I think that is important is because, again, in a school building, you have a building administrator working very closely with their teaching staff. Sometimes you have building principals and teaching staff who work together for years, who are close coworkers, basically. And I don't want to have a situation where a principal is having to investigate and potentially could have a bias or conflict of interest. So if it involves a staff member as an alleged perpetrator, or if there's any other form, any other combination of complainant and respondent, that would go to HR for the investigation. But I think that's better, Jessica, to add that in there so that it's clear who handles those and that we highlight that.
That's great.
So
I
if-
have
I'm
other
sorry.
questions. Sorry, I'm like the queen of questions here.
Oh, this is great.
To have some sort of a statement in this policy instructing what folks should do if the person that they might have a complaint about is either listed as the compliance coordinator or the person to do the investigation, like knowing that there are lots of folks with a formal role on this policy, what if the individual that you have a complaint about is actually supposed to have, so any other, okay.
So that's the way that I handled it, because what you will see in some policies, and feel free to disagree with me, let me know if you think this works, but what you'll see in other policies is they'll say, if the complaint is against the compliance coordinator, then you report to this person. But a lot of times that person is high up in the administration too, and might also be uncomfortable. So I thought it was important to say, you can tell anyone. You can tell anyone, and the complaint is initiated, this process is initiated regardless of who you report it to. Because if you report it to your school secretary, because that's a friendly face that you see every day, that person is going to be trained and they're going to know to get that up to the compliance coordinator so that they can make sure that the investigation process initiates.
That's great. Thank you for that. Another couple questions, and some of these are just clarifying.
Yeah.
We do not allow under this, like, what is there room in this policy for an anonymous complaint?
For an anonymous complaint?
Mm-hmm.
So, I think that what would happen in that case is if someone, and let me find this language, formal complaint. Okay. So if we had someone, let's say the way that comes through is, I'm the compliance coordinator, someone knows that, and I find a letter on my desk. I'm not comfortable giving you my name, but this happened. And I had no way of figuring out who that victim was. Then it would be up to the discretion of me and John, who are responsible for making sure that this policy is appropriately implemented, to decide whether we initiate the complaint process anyway. And so what I would say is that if it was something that came in under like highly suspect circumstances, maybe we wouldn't, but in most cases, we are going to defer to investigating. So that's how that decision would be made, is that the complaint could just be signed by the compliance coordinator who's initiating the process.
And then probably depending on how much information is in whatever anonymous information you get, you may or may not have enough to investigate, right? You don't have. Okay, that answers.
It have to be like a circumstance where I thought that use of our district resources and administrator time made absolutely no sense because it was so unlikely that this has any merit to it. That's the kind of circumstance I would decide not to. But certainly if something came forward, and now, there's going to be obvious hurdles to an anonymous complaint, right? I mean, there's obvious hurdles you might not be able to substantiate. But what you do is you create an investigation record, and you have that in our centralized record keeping system, so that if there is a complaint against that same person later in time, we're going to take into consideration that we had an anonymous complaint before, and we're going to give that information appropriate weight in the subsequent investigation. So you start to kind of look back and say, is there a pattern here that we need to be paying attention to? Good question.
And then, and I think I might have gotten a little lost in reading this between the Title IX, where we pulled Title IX out as opposed to the general process. But if an individual makes a complaint about harassment or discrimination in Shawnee Mission School District, is the complainant, will they receive information about the outcome of the investigation and whatever the remedy is that's been offered?
So there are different confidentiality laws and restrictions that come into play depending on the identity of the parties, whether they're students, whether they're staff members. But a common question that comes up is, if there is a student respondent, right, a student perpetrator, is the student victim entitled to know the discipline that was imposed? And the answer is no, because that's FERPA protected, right? So if my student has violated this policy and they're going to be out of school suspended for a day, as the parent, I get to know that information and no one else does. However, there are things that we can do. We will tell the victim that remedial measures have been instituted. And then we can make sure that the remedial measures are appropriate to when, for example, that perpetrator might be back in school. So, we might be saying things like, for this school year, you're not going to have to worry about interacting with that person. Next school year, we can look at these things. So we can't tell them exactly the discipline, but they'll have a good idea through the communication process.
Okay. And what about like staff on student circumstances?
It depends. If the board has taken action, those actions are public record. So they would get to know. They absolutely would get to know about that. And again, staff members have less confidentiality protections than students do. And so, again, those are questions that, for example, John and I would be helping investigators to answer and to craft. But what we would probably say is, like, let's say a staff member violated this policy and the appropriate remedy was putting a memo, issuing them a disciplinary memo. That was the appropriate remedy, or part of the remedies that were instituted. We might say something broadly like disciplinary action was taken. And we're not going to hand them the memo that's in the personnel file, but we could provide more information there. And certainly terminations are public record. They're in our meeting minutes. So that information would be shared.
I think that's just helpful for folks to know, because I think it's important that that this policy and the conversation captures the fact that there can be a whole range of disciplinary measures that are not obvious or known to people who are making complaints, that are not happening. They're just not necessarily public information because of confidentiality and FERPA and other rules we have to follow.
Absolutely.
And then my last question, sorry, was, I know you mentioned that KASB has some policies around this, and rather than adopting outright what KASB has suggested, we're developing a custom policy for Shawnee Mission School District, which I really appreciate that we're doing and that we've really vetted it so carefully internally. But how does, are there any like key differences between this policy and what are the key differences between our policy and what KASB has suggested? Yeah,
good question. So when KASB came out with their summer 2020 policy updates, they, in substance, sort of did the same thing. They were mindful of these new Title IX reg requirements, and they updated their policies that address sexual harassment specifically to incorporate language from these new Title IX regs. But they kept their structure that they currently have, which is multiple policies, multiple non-discrimination, non-harassment policies spread over the A series, the J series, the G series, and the K series. And I'm just personally not a fan of having multiple policies like that. I think that you have a much more understandable, accessible, usable policy when it all lives in one place, and where a person who maybe is unable to, maybe they know they were treated negatively or adversely, but they don't understand why. They don't have to read 5 different policies or try and put themselves in a certain box. They can go to our single policy, and we're gonna comb through all forms of discrimination or harassment and determine if our policy, which prohibits all forms of harassment, regardless of the identity of the parties involved, has been violated. So a lot of the language you see in our policy AC is going to look a lot like KASB's suggested language. It's just that it lives in our policy AC now. So I did review. I actually finished drafting this before KASB came out with their updates. But then I just read through them to see if there was anything they did better than me. And some things they did. So I just stole it and put it in our policy. So the language, again, because a lot of this language is our old language, but it's just in AC now. And because I read their updates, it looks similar, but ours is organized, I think, just a little bit differently too. I think headings.
Comparable. It's just we've organized it to be more user friendly
Yes.
for our purposes.
Yes, that's a perfect summary. Thank you.
Awesome. Any more questions, Jessica? Yeah.
Nope.
Thanks for that.
So timing, Dr. Fulton, what are the timing? I heard the word student handbooks, 2 words, and I know that those. And we have a meeting Monday. Then we don't have a meeting again until into July, the end of July. And so, what are you suggesting on the timing of putting these on the agenda?
Well, I would suggest that we put this one on the agenda for Monday as a first read, and then we finalize it in July. And that way, we have this policy in place before school starts.
So would it be before, let's just say, I don't know what's happening exactly at the July 20th meeting, but we have a meeting July.
It would be the July
27th, right?
Right, July 27th would be the final read and the vote for approval.
Does that then give us enough time to get that updated in those handbooks that students then get and have to sign off on, when they're registering for school? Or you know what I mean? All that stuff that they do?
I do. Rachel, the magnitude of the changes here, it references a policy. Are there specific changes that you're aware of that we would need to get into the handbooks? Because if that's true, then we would need to get it approved Monday. Do you know the answer to that?
Well, I mean, my understanding is that the entire policy AC would go into the student handbooks, verbatim.
Verbatim, the entire policy. All right. So having asked that question, I think it'd be if the board would be comfortable approving it Monday night. It's pretty short notice. That would certainly be a help because we need to get the student handbooks up and running in time for the kids to have them for school, obviously. Now, most of what we do here is electronic. Most of what we do here is electronic, by the way.
Right. I don't know when that process starts, like of, they call it something, I can't remember now, but when everybody goes on and they affirm everything, for their student, to be in school. And that's
right, do the enrollment,
sign off of that, right? And so that has to be included. Right. I don't know when that process starts. So does it start before July 27th? I'm assuming it does.
Well, I would have to double check on the date on that. And I can find that out.
Okay.
So,
because it would be butting up against it pretty. I'm sure
it's pretty close.
Yeah, if we wait until July 27th to approve it, I mean, in the best case scenario, because we're making so many changes, it would be a best case scenario would have a second read on it. But Jessica, what are your thoughts on that?
Yeah, I think we definitely at least need a first read. I don't think it's a big change. It's a big policy. It's an important topic, particularly right now. So I think it's pretty important that we have time for input, even if that means we aren't able to approve it until July 27th.
I mean, I think I could help whoever is responsible for creating those. We could get the policy language in there and delete out the old policies and have them like ready to hit go on. And I just don't know, and I don't know if you know, Dr. Fulton, the date. I mean, in my head, I'm thinking, well, they have to be ready by the first day of school, which is not till August 12th or whatever, but I don't know.
Right.
And the other thing would be your training on that too. If we wait
right.
July 27th, the administrators come back like about the 23rd, something in that range. And when you were planning on doing that training, was it when they first come back, or so if it need to get this really done. I don't know. What are our options on July 20th? Do we have options, Dr.
Well, we could on July 20th. It looks like right now, the only thing that we would have on the 20th is going to be the reopening plan for school. I think that the survey is going to have to be pushed off to the 27th. Doesn't look as the results are going to be quite ready for us, the community survey. So we would have time in a special meeting on the 20th to address this policy as well if we wanted to.
Is it a special meeting that allows us to vote on something? It's not it's not considered a workshop. It's considered a special meeting?
It is a special meeting, and you would be able to vote, yes. Yep.
Jessica, what do you think of that?
Yeah, I think that's great. And I think regardless, I encourage you guys to be moving forward with whatever training plans need to look like, because I imagine whatever the tweaks are, they will be on the margin, and having those trainings all figured out. A lot of that can happen with the content to be like finalized, right?
Yeah, we'll have to go ahead and get the trainings all set up. Well, assuming substantively this is approved as is.
Yeah.
We wouldn't have time to wait.
And some of the training is going to be dependent on the policy language, but some of it, like I have to do, I'm going to need to do specific Title IX training on these new regs, and that's not dependent on policy language. So I think a lot of it we can get, again, set up and ready to go.
I might add too, the combination of waiting on the Title IX finalization and the interpretation of Title IX, along with the delays that, frankly, the pandemic has caused, push this work back to this late date. Otherwise, we would have probably been, could have easily been a month ahead of time right now.
Yeah,
it would be great to have it done in May. It just wasn't possible.
I mean, KFB just came out with their suggestions. Was it last week?
Yeah.
Right, and that was part of the challenge that we were facing.
Mm-hmm.
So, anyway.
Well, are you all comfortable with the fact that we would do then a first read on this on June 22nd, right? Next Monday. And then a second read on this on July 20th, which is the special meeting. Are you all okay with that?
I'm comfortable with that. I'll tell you what we'll do. Let's just go ahead and plan on it. If for some reason we feel like there's a procedural problem, we can still do the first read, and if we have to set up a special board meeting for approval of this policy sooner than that date, then we can work something out. But we'll try to adhere to that approach.
Okay. I agree, though. If we can do it, I prefer a second, because this is it's so important, and it's also just so important that we have buy-in. And so I feel like this is really strong, and I've spent, I think, 80 hours on it. So I feel like it's perfect. But I mean, we just had examples of Jessica finding 2 ways that there were places where questions could be answered better, where things could be clearer. And of course, our policies can always be updated, but this one is just one we need to get right.
So on the agenda then for Monday and for the and on the 20th, so we would have basically 5 new or revised policies, like AC, GAE, I don't need to go through them all, but 5, and then 1, 2, 3, 4, 5, 6 deleted policies, ones that were deleted, correct?
Correct.
That is correct.
Yeah. So that would be, we would have 11 policies complete on the agenda for Monday night, then first read only.
Correct.
Okay.
Yes.
Okay. All of them first read. Correct.
All of those first read.
Okay.
Now
that'll all be under action.
Well, I know once it's put on their first read, though, you can't have someone motion first and final, can you?
You can.
Probably not advisable, though.
No, I wouldn't advise it. I think it's important to go into these meetings with a really good understanding of, is it going to be are we going to approve it that night, or are we going to do a first read? And what we've tried to do, as you know, on a lot of these policies is, for the routine things that involve very minor changes, probably don't need a second read.
Right.
But for others, substantively, try to having a first and second read has value to it.
Right. Agreed. Okay, well, it sounds like we have a plan. And so, yeah, Terry, if you can make that happen for Monday night, that would be great.
Okay.
Dr. Fulton, will you be the one explaining like all of these things? Rachel?
I think this would be a great opportunity Rachel, for you to you get a rare appearance in a board meeting and kind of do the high summary overview. That would be my recommendation.
Okay.
So
Giving your
that's your call as the chair.
I'm happy to do that if you guys want me to.
I think that would be, a really good, I feel confident in my own abilities. However, I feel more confident in your abilities to explain all of this. So yeah, I think that would be great if you can do that for us.
Sure.
So then when the policies come up, I can just, or Dr. Fulton can throw it to you if that's fine.
Yeah, you send it to me, and then Rachel, you'll need to be a panelist so we can.
Okay.
She is.
Put you on there.
I have her on the list.
Great, thank you.
Okay.
So Rachel, will you send me all these policies again? I'll need them as Word. Yeah, I'll need them as Word. I'll make them PDFs, or I'll do what I do in Board Docs. But yeah, so I'll need them to make the changes in Board Docs. I'll need them as Word.
Absolutely.
Okay.
Now, in the recommended action, Terry, you'll have in there that this is a first read, correct?
Yes, I'm going to go back. I've got them all in. I mean, I've
Not
got
in there
all the
right now.
placeholders in there, but I'll just go in and make them all. Yeah, I have an appointment that I have to get to, but I will, when I get home, I can do that tonight or yes, I can, or tomorrow morning. I'll do it. Yeah, I'll get it done.
Yeah. Okay, great. Thank you.
Perfect.
Is it, Sarah, I don't know if it's appropriate, but if we had a little time to talk through the board manual timing.
Sure. So Rachel, Dr. Fulton, does Rachel need to stay on for this or no?
No, I don't think so.
Okay.
Unless you want to, Rachel, it's up to you.
I believe my children are about to slam through the door that's to my left like any second now. So.
Okay.
I have one question for you, Rachel, really quickly. If something in the board manual needs to be, okay, if the board manual states something that's not in policy, then like about our board meetings and things, then do we need to change? I mean, I guess we need to look at those policies then, correct?
It would depend on what it is. So if it's something about, the high level of how we operate at our board meetings or our public notices or anything that might have like COMA implications, that we would need to look at. But typically your board manual is agreement amongst the 7 of you about how you serve, fulfill your responsibility as a board member and how you interact with each other and how you interact with our superintendent. And none of that has to be reflected in policy.
Okay.
So anything that you want to flag, like, hey, check on this, does this have a policy implication? I'm happy to do that.
Okay. All right. Good.
So I think the main thing was, this transition that are we talking about at Monday night with the organizational meeting, Dr. Fulton, this moving to like a workshop format in meetings, whenever we have a month with 2 meetings, the first meeting would be a workshop format and the second meeting would be a standard board meeting. And whether that needs to be reflected in the board manual or in policy or in both. And I briefly looked and there is a policy about board meetings.
Is a board workshop considered a regular meeting? I guess that's my question.
Yeah, because there's a quorum.
Okay, so it's considered a regular meeting, and it does say the regular meetings of the board are held the second and fourth Monday of every month, depending on different months are different. But so it's considered a regular board meeting.
It is considered a regular board meeting. It probably would have value to at least put in the in this document, in the board manual, what the function of a workshop is versus a regular meeting. I mean, the workshop will have some consent agenda items on there that are standard, right? Human resources, et cetera. typical consent agenda items that would be considered routine. But that would really be it. Other than that, it's going to focus almost entirely on updates related to the strategic plan.
But
And
it really is of our own choosing what we put on the agenda for that meeting, but it's still a regular meeting of the board because there's a quorum present and we can still vote on consent items.
yes,
But we just choose not to put other things on there present. We're doing specific presentations and stuff that we know we're not going to vote on, that we might have future votes on. Correct?
That's correct. That is correct. Yeah. And then of course, then as a board meeting, then you would have to also make decisions about, are we going to have public comment? Are we not going to have public comment? If we are going to have public comment, where is that done? Because one of the things that you get into with workshops is, I imagine we're going to have from time to time presentations that might involve students or parents and teachers. And so part of it is trying to honor their time. So they've got a predictable time frame when they're involved in a presentation and they're not delayed, going on with their life work. So those are the sorts of things that we would have to make some decisions on. Now, the pressure is off a little bit because we don't start our first workshop until September. Everything until then is more regular board meetings. We have a little bit of time to get this done. And I know that we're talking with Heather and Mary about this, about the idea of a retreat sometime there in July. And we could definitely spend some time on this at that retreat as well, for getting it finalized. So,
and that would be great because I know that's a longer time frame, but it is scheduled sometime in mid to late July, and that would give us time to, a public setting in a workshop or a retreat to vet it and talk about it and make sure it's all right before we put it on the agenda. And I know that these agendas with 11 policies on there, that's a big deal. So it's a lot. So if we look at the time frame of potentially July 27th, which would only give us a week, but we do have 2 meetings then in August where we potentially could get this. And we have a board manual that's currently in place. It's in place. These are just the corrections to it or the revisions.
The board manual doesn't require a first and second read. I mean, it has a different function than that in policy.
Right.
So, so I think you'd be fine. But it would be helpful to define what the purpose of the workshop versus a regular meeting versus a special meeting.
Right. Because I think actually in the board manual, it kind of goes through the agenda of a regular meeting, and it states what the agenda is, and there's certain things on there that might not be in a board workshop, and that's considered a regular meeting. So maybe even we could take that whole section. I don't know. We kind of need to look at that probably too.
Work that a little bit.
Mm-hmm. Yeah.
Curious, Jessica, what are you thinking?
Oh, I think it's just helpful to understand what has to be where, because I don't want us to, if there's policies that have to be updated and we want to first and second read them, I don't want us to be bumping up against time frames where we want to start transitioning over to a board workshop format in September, but we have policies that are out of compliance. And I also don't want to hold up any changes we want to make to the board manual, because I think Sarah and I talked about some changes that needed to happen to the board manual, but we weren't sure whether we should just put pause on that until we incorporated this board workshop. Yeah, so I think it's just a matter of knowing, anticipating that that's a change we've talked about wanting to make.
Yeah.
To show up.
Well, I'll tell you what we could do if we had a meeting between now and the board retreat to kind of do the final cleanup. Then we could also cross-check and see if there's any implications for policies. That way, we could get it to the board on the 27th and get it after the retreat. I think the retreat could be that week of the 20th sometime. If we're able to do it then, that'd be really good timing, actually.
What if we, do we have a policy committee meeting set up for July?
Do not believe that we do, but
Terry might have put them.
it's possible.
Mhm.
It is possible.
July 9th. We have one July 9th.
Is it?
And I am happy if there's anything that you guys identify in the board manual that you want reflected in our current policies, I'm absolutely happy to work on that. And even if it's something that's not legally required, if we feel like it's better to more clearly identify our meeting structure in our policy just for purposes of public notice, we can do that. I would just say that, and I can easily do that by July 9th, but I don't see that as being like something we have to do by a specific deadline for legal compliance.
Right.
Is July 9th, does that date work for everybody? Dr. Fulton, does that work for you?
I believe that it does, and even if I've got a I'm on vacation that week, but even if I've got a conflict, I can work that out with the two of you. I mean, the good thing is that you're going to be working on analyzing the draft language, and it's still going to go through with all the board members, and I'll be there too at the retreat. So
Right. So
Yeah.
Jessica, does that work with you then? Then whoever's around and available, if we don't have any other, on July 9th, if we don't have any other policies that push it out of the way, we'll do the board manual. You and I can discuss it. If Dr. Fulton's available, if Rachel's available, we'll do that on July 9th. We'll go through the draft and then have it ready to present in that public format of the retreat to the rest of the board and get input and whatnot on July, whatever, 22nd-ish, whenever we're going to do that retreat. We're hoping for around the 22nd, but I don't know. And then have it for hopefully the board's approval, either the July 27th meeting, or if that's just too crazy busy, into August, that first meeting, which is around August 10th, I think. Does that sound good?
And I'll make that July 9th meeting a WebEx meeting, because right now it's not. It's just a regular, because it was from way back when we put this on. So
Okay.
From the original calendar, yeah, it definitely needs to be a WebEx meeting.
Yeah.
WebEx meeting, yeah.
Yep. So.
Okay, awesome. Well, I'm glad we have a plan for it. I have that written down, and awesome. So we will get that done. Good.
That's great. And as a reminder, that draft version is there in board docs for you. So
Okay.
in the
Is that
library.
the draft version? Jessica made some suggestions to it. Is that your draft version, Jessica, that you had some suggestions, or no?
I don't think so last I looked, but
Okay, well,
I don't think it has. Yeah, I don't think it has her changes in there, her suggested changes in there.
Okay. Well, we can discuss that on July 9th and make sure we have that one too available to us. Okay.
Hey, that's great.
Well, I think we're done. We done?
I think we are. I think that's it.
All right. Well, super. Appreciate everyone's time, and we will see you on Monday.
Thank you
Okay,
guys for
That's
listening.
great. Thank you very much.
Bye.
All right, take
Thanks,
care.
Terry, too, for your work.
Of
You're
course.
welcome. Bye-bye.
All right, bye.